legal minds as we continue this conversation. We're looking, gentlemen, good morning, karibu sana. We're looking at the big day, the very last day of this window in which anyone can file a petition challenging the repeat presidential election of October 26th. And what we can expect going forward, it is a big day. We've just come from a similar process after the August 8th election. We went through this Supreme Court process. How different do you expect it to be this time round? No one has filed so far. But that should not say anything much, because last time it was filed at 11 p.m. We still have a lot more hours too.
I think suffice to say that we still have 24 hours, not 24 hours,
it's about 20 hours.
20 hours. Somebody can file, because this is the last day. When somebody files under Article 140, the matter of the process, as was the case previously, and the court will have 14 days to determine that matter. And I think what is important to emphasize, even as we file this petition out, I've seen the posturing both on NASA and on this part. I don't think there's a shared understanding that the court's decision should be binding, which really makes me worried this time. Unlike the 8th August election, where people went to court and there was basically an understanding that yes, let the court decide either way, we will be bound by it.
Are you saying this time around?
I have seen some posturing that perhaps I think is disturbing, say the least, because the reason why people go to court, when you go to court, the judicial decision ought to be binding on everyone. Is NASA really genuinely committed to abide by that decision if the court finds that the election was actually conducted as per the Constitution, because they must abide by that decision? Is Jubilee genuinely ready to be taken back to another third election? Because remember, they participated on
the 8th August. Possibility.
Yes, a possibility. So I think let us not use the judicial process to claim some mileage depending on how the judgment goes. I think if the case is filed, it will have to be decided either way. And let us not delegitimize the court. If the court validates the election, I hope NASA will do the practical sense thing, which is to preserve the rule of law and not to undermine judicial authority, because the bindingness of the highest court in this country must not be undermined. So for me, that is what I want to keep in
Mungai. Pronouncements by both sides of the political divide leave a lot to be desired. NASA says they no longer have faith in the judiciary. They do not see like the judiciary can actually rule the way they want. On the other hand, Jubilee has already gone ahead and said that there cannot be another election before 2022, which is prejudicial. The court can actually say, nullify this process and say, let's go back. Don't you think that both should be considered to be in contempt?
Well, my view is that NASA even taking the court to court or directly or through its surrogates, it is a matter that they are doing it as part of the political delegitimation process. As in, you raise a serious issue, the court may hold one or the other issue was not okay, and then that would give them some further ammunition in their political game plan. But again, to be fair to Jubilee, I think the president-elect, who I would take in this instance is the leader of Jubilee, and whose election would be challenged, if at all, said that before he says anything about way forward, he wants to have all these constitutional processes concluded, and he said he was going to abide by it. So that that is a statement that I would wish to go by more than any other person saying that there will be no elections up to 2022. Of course, ideally, that is the wish that they have. Even my own personal wish is that the country has had enough, and this issue, bearing in mind, the whole idea of nullifying an election is in order to do another election, going by the demands that were given by NASA and the true reasons why they never wanted an election. Remember, my own view a day after the nullification on 1st of September, I say the Supreme Court was likely to have an egg on its face because I did not see the possibility of NASA being interested to go for that election. So when finally they looked for an excuse not to go to that elections, I think to me that should have been foreseeable. It was not rocket science, and therefore what the judges will not repeat again, I am sure, whatever petition is filed, is that in the absence of people genuinely wanting to have this repeat election, why should you order it? So it's highly unlikely they will order it.
And the other big question is, there's been a lot of talk about the power power that the Supreme Court wields, and we had not up until September 1st seen that kind of power, where the Supreme Court can actually nullify a presidential election, and the whole world was shocked. But it appears that that kind of power has faded. The questions being asked about that day that the Supreme Court was not even able to form a quorum, a proper bench to hear any matter, and people are saying that the court appears to have changed in some way between when they made that pronouncement on September 1st and today. Do you agree?
I think, well, I would not want to pontificate in that manner, but I think because of the question you've asked, I think Kenyans may have missed the proper conceptualization of the arrangement of power under this constitution. Because if you look at, I know this clamor for the presidency, actually, the presidency of pre-2010 and post-2010 is completely significantly reduced even in powers in terms of what we call the horizontal dispersal of powers.
But
the judiciary,
in terms of perception, we still see the presidency.
Yes, you see, in terms of the horizontal dispersal of power, the judiciary, we have now what has been described as an ascendant judiciary, a judiciary that is impervious to executive manipulation, a judiciary that can nullify a presidential election, parliament that is bicameral, that can effectively, if they want to, oversight the executive, and we have independent constitutional commissions that also offer additional layer of oversight and support. When in fact, in terms of vertical arrangement, we have this now state-powered resources being shared between national government and county government, and really, this government, I think they have committed about 40% of those resources to the counties, meaning that the level of power and resources at the center, at the presidency, have been significantly reduced. Beyond that, we have really a strengthened Bill of Rights that makes it possible for people to engage directly with this government and even show disaffection. And there's a requirement of public participation also, that before any government takes a decision that will affect the public, you continue to engage them. So I think what has been lacking, which is a question of framing, the inclusivity, which is also a key component, the inclusivity that the Constitution presupposes or envisions, is one that allows for inclusion of marginalized communities, groups such as women and youth, persons with disabilities. But the reframing of inclusivity by a political class is what has put us into this crisis, because inclusivity has been due to think that until you have one of your own sitting at the presidency, then you're not included. But you see, that framing must be understood by two contexts. The first one is that Kenyans, the fact is this, Fred, Kenyans are excessively ethnic. So when it comes to politics, sometimes you really don't want to accept that the Constitution has passed power, and really the president has been mystified that it doesn't really matter who sits there. You still insist, maybe for sentimental reason, for whatever reason, that to see your man there has some value add. Yes. Even if it's not going to do anything that will improve you, which the other person can't do. The other issue, which has also not been attended, is that there's a reason why this country is ranked number 145 out of 183 in the Corruption Perception Index. That means sometimes what politicians tell us is not what they mean. It could be that the struggle for the presidency is actually a struggle for co-option into the club of resource managers, so that, you know, when you're there, you can easily also have an opportunity for personal aggrandizement. If you look at all these things put together, you will see that really this presidency, if it's possible that the Constitution can work the manner in which it is intended, then it really doesn't care who sits there. Because of that, the Supreme Court is not afraid of nullifying that election.
So as far as you're concerned, the Supreme Court is, if at all they sit today or tomorrow, is still as powerful as it was on September 1st. They've not lost anything, even in terms of perception.
Perception they've lost a bit, and I think there's the opportunity for them to redeem itself. What we can't deny is this. You see, the explanation given by the Chief Justice was not satisfactory at all. When the Chief Justice says, and I wish he could have done better in terms of communicating differently, he said, especially with regard to the DCJ, the Deputy Chief Justice Philomena Mwilu, she said, all of us are aware about what happened with the DCJ, you know, and then what being aware means her bodyguard was shot and I think injured, and then now she was afraid of coming to court. Judges have sworn to defend the Constitution without fear. So then when the Chief Justice speaks in a manner to apologize, then it creates room for intimidation, because, you know, if you intimidate judges, I think it would have been better for Philomena Mwilu to even resign as a judge of the Supreme Court if she thought she's unable to work, than to abscond court and say, because of fear. Yeah, that's what creates the perception that now the judiciary is no longer independent.
Something has changed.
The problem by the Supreme Court, we can only blame them.
That failure to get quorum on that day, on the 25th of October, speaks a lot. That's what is being used to actually judge the Supreme Court and say, hey, we're not really sure they are still as powerful as they were in September.
I think before somebody casts the first stone to these judges, the first issue, first of all, I'm not excusing the fact that they didn't turn up to perform their functions, but it is also important to understand context. And the context here is this: you go into court, an election petition is a legal, political adjudication. You use the law to adjudicate a political dispute. Now, to the extent that this is law, the expectations of any court is that if we give you an order whose operative part is that there is going to be another election, and now this order, instead of using it to take the second chance to do the election, you decide to put it into the use of trying to procure under constitutional crisis and a clear determination not to go for this election under any circumstances, then the judges were bound to have a pullback. And this pullback is part of what you saw and say, you see, the judges, even at the most activist and at the most radical, they still remain an institution that expects that the existing law under which they make their order, and their order is supposed to be legitimate, is going to be followed. So that if they see that we give you an order, and this order you have no intentions of using it to the manner in which we thought we were giving you, everybody is going to be afraid of you.
But
so I would actually see
one of the respondents, because surely this is an election, a presidential election. That's the only court that has jurisdiction over such. Yes, a day before the election, judges cannot, even only 2 judges are available for anything. Anything could have come up.
I'm not excusing that, but what I'm saying, all that I'm saying is the issues of context. That at the end of the day, if, for example, particularly to NASA, if somebody now, it happens that you are suddenly afraid what all this means, that you now hold again the country one day before the elections, or on their toes, and you don't know how you are going to react to this. Everybody was going to have a reaction that, well, we are not probably dealing with a normal litigant, and we are now dealing with an entity that is clearly committed to ensure that we are not going to follow the laws as they are, but we have another agenda.
But it is the issue of that agenda. Just looking at NASA, because this court should serve everyone else, including the IEBC, which runs the presidential election.
What for sure, what we can't, it's not open to debate. The explanation given by the Chief Justice was not encouraging at all. It would have been better to say, because you see, the Supreme Court is a court. Yes. You something just when you moved a day to the election, you run the risk of not finding judges, because they were not programmed to be there on that day. They could have traveled. You get, but to tell the country reasons why judges are not appearing, some of those reasons are not undermine the spirit of the Constitution and their duty as a judicial. We must call them out for that. Is what it is, and we can't excuse. We blame,
and that has affected how people
the perception. Yes. Now you see, NASA, for instance, is riding on that perception that this is a court that has been intimidated. That is a crisis generated by the court itself. They can only blame themselves for that loss of perception. You know, the rule of law, Fred, is although it's a very crucial ideal, but it's also equally very fragile. Fragility, part of it depends on perception. If people begin to perceive the Supreme Court as a court that is pervious to external manipulation, the motivation to go there will be significantly reduced. So I hope that the way judges now, this court process this issue, they must be able to recapture that.
It's a very challenge, but they must venture, because we run the risk of saying it as another opportunity for them to redeem.
No, that's not the issue.
Which is not fair. They have to redeem themselves.
Allow me to introduce Rachel Masika, joining the panel, also a lawyer. Karibu sana. It would be good to hear your perspective on this matter as well. And we're now looking at the very last day of that window in which any person interested in filing a petition challenging the results or the election or the process of October 26th as the repeat presidential election can do that. Midnight tonight, that's the last minute you can actually do this. Rachel, we're talking about the matter of perception now. Yes, we've come from a situation where, and this is just back to back, September 1st, the Supreme Court make the judgment that everyone applauded, the whole world was shocked, some were in awe, Kenya was praised, you are such a powerful court, you are such an independent judiciary. Here we are, a month and a few days later, that perception appears to have changed somewhat. Do you agree? And what should we blame on that?
I agree that the perception about the Supreme Court has greatly, in some way in the public domain, diminished, in that, as counsels have been saying here, that the judges seems to be intimidated in some way with regard to what happened on the 25th, where some gave some, I will say, very funny reasons, like
some did not even have reasons.
Others did not even have reasons. The deputy DCJ might have had a very valid reason, but then we should ask ourselves as Kenyans, if deputy CJ can even be attacked under this democratic country, and where we believe that our safety is in the government and it lies with the government and the institutions that are supposed to safeguard us. If the person that we really believe that they should have the maximum protection can easily be attacked, of which no one is talking about that anymore. It happened, it was on papers the next day, then it went like that. No one is talking about it. What about us as normal mwananchi? How will I even have that? How will I even have that confidence for me to even feel that if I move to the Supreme Court, that I'll not about even being safe, that the same judges who feel intimidated, the same judges who are not even protected, will be of.
And that's exactly what NASA is saying, yes. That they no longer have faith in that court, that the court, the kind of supremacy they had appears to have diminished. Appears. Do you get what NASA means by that?
Yes and no. Yes, because if you are...
And I'm not suggesting that NASA will not
precisely. If you are from the moon, you would actually be able to say NASA is right. But you are in Kenya, you have just seriously betrayed the trust of this court. The court gave you an order on the trust that this order will only be used for the legitimate purpose of ensuring there is another elections to be held in accordance with the law. The law means existing law. And that is why, personally, I objected to passing new laws. But not a law in accordance to the demands that you are making. And therefore, if you have just betrayed the trust of the court, then you say, oh, I don't have faith in you, you are not this. How are you addressing your own issue that you are, if one was to say so, the first villain in the act should be yourself? Because, and we must never forget that the crisis we are actually facing in Kenya, in trying to say IBC is not independent, the judiciary is not as strong as it was supposed to be, is this: that over the last 5 to 10 years, a section of Kenya seems to have lost or to be losing faith in the elections as a fair arbiter in the game for political power. You may do anything else under the world, but never forget that as long as there is a general belief that the route to power is not, and that's why you are having all these movements and resistances, and that the route to power is not necessarily through elections, then you have a crisis that even the Supreme Court, as currently provided for in the Constitution, cannot remedy. Because how do you remedy a problem that is essentially political and essentially no citizen in a constitutional democracy should have? That if you want power, there is one route, elections. But you are losing faith in that.
We're just about to take a break, but before that, Steve Ogola, even NASA should take pride in their contribution towards what the Supreme Court, that ruling made by the Supreme Court on September 1st, that no one expected such a pronouncement by the Supreme Court, but it happened. Don't you think that NASA should have just been fair to Kenyans and at least helped protect that new perception that we have in our judiciary, that they were able to do this, then it should be incumbent upon us to ensure that even going forward, they're still able to do this, that we still have at least some faith in the judiciary, instead of saying, these guys, now we no longer have faith in them.
I think there are political questions which must be left to politicians, and there are legal questions which must be left to the judiciary. The judiciary should address itself and limit itself to issues of the law and not care about, if people don't
blame the Supreme Court.
No. What I'm saying is this: the Supreme Court, if once it delivers an order, it's not allowed to comment on it until someone comes back. Yes. So then if a matter is reintroduced back to the court, then they will have an opportunity to examine even the context and say what the law says about that. But what I'd like to comment on is this: if you look at the parameters for boycotting election, I have had previously personally have said I really didn't see significant reasons why NASA could not go to election and document the challenges and then present them to court. Because if you look at the manner in which democracies generally work and how the political opposition boycotts election, there must be a serious climate of fear that incapacitates a leading candidate from campaigning, threats with life, poisoning, attack on his supporters. Because election, to be the leader of the election, there must be campaigns. So if you're not reaching out to your supporters, your support base, you're not communicating ideas and agenda, how are you expected to have voters who can make informed decisions at the ballot? So because of that, you may actually boycott an election. But the framing that NASA used for sure, there are things that could only be interrogated based on evidence, and the proper forum was the court. But nonetheless, they made a political decision to boycott the election. The election happened as per the constitution because there was no order vacating that election. The Supreme Court now is likely to be invited to interrogate this election, the outcome of this election. I would hope that the Supreme Court would not take not put so much weight that NASA was not in this election. Let them examine the context in which the election was conducted, and if they think the election met the threshold that they have set for themselves for this country in terms of interpreting the law, let them be happy to validate this election. If they find the election does not meet the required threshold, let them also be happy to invalidate and let the politicians deal with the intended and unintended consequences.
Okay.
But they should not respond to external pressure or manipulation.
Yet the court can only respond to what is presented to them.
Yes, certainly.
And there are many questions that people would want clarity on from the courts. What happens in the case of one candidate boycotting? What happens in the case of these new electoral laws? There's so many questions that can only be answered if this is presented before the courts. We'll be looking at that. What are these issues that should be presented to the Supreme Court, that even if the ruling goes either way, at least in terms of jurisprudence, we'll have some clarity from the courts going forward. That after the break.